Live stream audio test 1 2.
Okay, good morning everyone. It's 9:30, so I shall resume this inquiry. My name is Luke Fleming. I'm a planning inspector appointed by the Secretary of State to conduct the inquiry. The appeal is made by Beechcroft Land Limited under the provisions of Section 78 of the Town and Country Planning Act 1990. It's against the failure of North Somerset Council to give notice within the prescribed period of a decision on an application for planning permission, and the proposal is described as outline application for the erection of up to 62 dwellings, 30% affordable housing alongside a new access, landscaping and other associated works, with all matters reserved for future approval apart from access. And it's at land to the east of Church Lane and north of Front Street, Churchill. So for clarification, it's an outline application for approval being sought for detailed matters relating to access only. This is day 5 of the inquiry, which is scheduled to sit for 6 days. I think it's on track. I think it probably will sit for 6 days unless anything surprising emerges today. Firstly, usual reminders, electronic devices, please have them on silent. There should be an attendance sheet circulating. Please sign that and hand that back to me at the end of the day. I'll aim for lunch between 1 and 2 o'clock with suitable breaks in between, morning and afternoon. I'm told there's no fire alarms today. If there is, the fire exit to my left, alternatively through the main doors, and assemble in the car park, which is to the right of the building on the opposite side of the road. Yesterday we heard both sides' evidence on housing land supply. Today, in accordance with the programme, which should be available online, but also you should be able to see it in the room, we're going to hear the appellant's and the council's evidence on planning matters. But before we do that, just check, is there anybody in the room that I've not heard from that wishes to speak to the inquiry today?
Good morning, I'm Councillor Patrick Keating. I'm the ward councillor.
Sorry, I just didn't. What was your full name?
Councillor Patrick Keating.
Keating, yep.
I am the ward councillor for Blagden and Churchill.
Ward councillor for Churchill. Are you in support or opposition of the scheme?
In opposition.
So do you wish to speak to the inquiry?
Very briefly, if I may.
Yeah, that's fine. If the parties are agreed, we'll do that first thing. Are there any qualifications that you want me to be aware of?
None, no. Apart from being the local councillor.
Okay, are you happy to answer questions?
Absolutely, yes.
Yep, okay, so the appellant's team may have some questions of you. I may also allow you to sort of ask questions of the appellant's evidence if you're in opposition as well. Okay, have you got any questions about the procedural side of things?
No, all clear.
Okay, so if you come and give evidence, if you could come and do it at the table, so come and set yourself up and we'll hear from you straight away if that's okay. Have you got a drink? Do you need a drink?
No, I'm fine.
Are you okay?
Sufficiently caffeinated and hydrated.
So you've got a microphone in front of you. You're more familiar with these than I am, no doubt. So, whenever you're ready.
Perfect. Well, thank you for giving me the opportunity to make a few remarks. I'll be brief because I think the arguments in opposition to this application have been well rehearsed by the council team, but by also representatives of the local community who gave evidence towards the beginning of this inquiry. What I wanted to do today was simply to First of all, re-emphasise and highlight the strength of local opposition to this scheme. I attended last night the Churchill Parish Council, where I had an opportunity to meet with both the Parish Council, but as well representatives of the local community who highlighted their concerns around this scheme and the impact on the village, its landscape, the environment, and the impact on already overstretched local services and infrastructure. And as local ward councillor, I share the concerns that have been highlighted by the community and by the Parish Council and ably set out in the course of this inquiry. The application before us would lead to a significant increase in the size of the village, particularly in a part of the village which already is subject to quite some pressure and has a number of protected characteristics. Already with the development we've seen come in place over the last few years, the size of the village has increased substantially, and we're seeing now significant pressure on services. For instance, the doctor's surgery is already overstretched, roads are at capacity. We've had a number of near misses on some of the local roads due to the increase in traffic due to recent development. The proposal also threatens the character of the village. It's grown substantially, as I said, going from a small local Mendip village to something that's approaching the size of a town, and that has an impact on the well-being of the local residents. Concerns as well around the landscape and the impact on the AONOB are front of mind and foremost, and again the proposal is in a rather sensitive part of the village. So I remain convinced that this application should be refused for those reasons, and again I won't rehearse the detail because that's been ably done by others before me, but I would simply say that this application is a part of a trend of applications we're seeing of a speculative nature which are unsuitable for this village location, and that further development in our villages should be based on a sound neighbourhood plan driven by the needs of local residents and the parish council and North Somerset, not by the speculative desires of developers. And I'll simply leave it there because, again, I didn't want to go into too much detail at this point because the arguments have already been well rehearsed and well made by others. Thank you.
Thank you for that. Just stay for a moment. Have you got any questions? No? I haven't either, but thank you very much. Okay, so before we start to work through the evidence, is there anything that either side wishes to draw to my attention?
Do you know, I was thinking about it. I don't think giving the inspector yet more paper is going to help. You're right. The extract you put in says no more than what I was going to put in.
Okay. Mr. Garvey, nothing from you?
No, nothing from me, thanks, sir.
Okay.
So we did put that in yesterday, didn't we?
Yeah, I've read that, thank you. Okay. So I'll just give you a couple of minutes. Take your time to just set up. That's Okay, so Mr. Leader, would you please call your planning witness, please?
Yes, sir. I'll introduce Mr. Stevenson. I'll introduce Mr. Stevenson to the inquiry, sir. Your name is Andrew Stevenson, is that correct?
That is, yes.
And you tell us in the proof of evidence that you've written that you are a principal planning officer in the Council's strategic development team, and that you've worked for this authority since 2002, before which you worked for the City of York Council and the University of York in the Science City York Economic Development Project. You've 23 years of experience in local authority planning, and the last 9 years of which have been spent dealing with major planning applications. By way of qualifications, you attended the University of Cardiff and obtained a Bachelor of Science degree in City and Regional Planning and a postgraduate diploma in Town Planning. Now, you've prepared, as I said, your proof, you've prepared a summary as well. So, with your permission, I don't propose to ask Mr. Stevenson to read that out. I know that there are people watching on the internet, but Mr. Stevenson, I wonder if I might take the liberty of summarising your case in this way, that you say that the scheme conflicts with the development plan for North Somerset by reason in particular of its impact on the landscape and designated heritage assets, which brings it into conflict with the relevant policies, and you'll be cross-examined on those, I expect. And whilst you realise, of course, that the absence of a 5-year housing land supply, which is admitted, is a material consideration, and it may, under certain circumstances, which you say do not arise, come to operate what's known as a tilted balance. Neither the absence of a 5-year supply, nor any of the other material considerations predicted by the appellant outweigh the conflict with the plan that you find. Is that a fair summary?
That is correct, yes.
Good. Now, having got that straight, the other thing I should have done, and I apologise for failing to do so, is I should have asked you, have you read your proof of evidence before attending the inquiry this morning, and just checked that there are no matters of fact that need to be corrected, having been found or illuminated as being wrong during the course of the hearing to date?
No, I'm happy with my proof of evidence.
Thank you very much. Well, with that all on the record, may I just ask you a small number of supplementary questions? One of the matters that was discussed with the appellant's landscape evidence, Mr. Cook, was the proper interpretation of core strategy policy CS5. What's that policy about?
Well, CS5 is a policy that deals with, well, provides a broad framework for landscape and heritage assessment. It's in alignment with the policies of the NPPF and NPPG, and it is reinforced within the development plan by the development plan policies.
Right, so CS5 is a core strategy policy. It is adopted, and as you say, it provides guidance on the protection of the landscape, amongst other things. Now, one of the things that Mr. Cook said in his written evidence is that the policy operates to protect landscape as a resource, but it's not really concerned with protecting the landscape from the visual impact of development. Do you recall that evidence?
I do, yes.
Now, is that an approach that you've come across before in your time at North Somerset Council?
No, it's not. I think that takes a very narrow view of CS5. CS5 has a broader remit in the assessment of the applications, and that's been backed up by a number of the appeal decisions which are in the core documents as well. I could take take you to those if you wish.
Well, I think rather than take up time trawling through those documents, what the inspector would probably appreciate, and I guess my learned friend might too, is just your telling them which decisions you would refer them to in due course with the reference numbers. If you could do that by reference to the core document numbers, then my learned friend's on notice about which decisions you rely on. The inspector can check for himself, and if it's a matter of contention, you'll be cross-examined on it, I expect. So which documents would you refer us to, please?
In terms of the interpretation of CS5, I would draw attention to core document G1.
Yep. Do you have a page number?
I would go for paragraph 16 to 20.
Paragraph 16 to 20, yep.
Core document G2,
Yeah,
where I'd look at paragraph 71.
yeah,
Core document G5
yeah,
and paragraph 37.
yeah.
And core document G6, paragraph 22.
Now, I don't want to rush for the sake of rushing. So having said I wouldn't take you there, I just want to ask you this question. If I were to say to you, pick one of those decisions and just show me the sort of mental process you went through as you arrive at your conclusion as to the correct approach to the interpretation of these policies, would you like to pick one and take us there?
Well, if I look at the first one that's on that list.
Should we go to G1? Let's
Yeah.
just do this properly. Yeah, okay, so I'm going to pull out G1. I'm going to go to paragraph 16, and I'm going to ask you to explain, please, why you say what you say about the proper interpretation of CS5.
I'll just grab that one myself as well.
So, while you do that, I will note that this was a decision of Inspector Richard Schofield, dated the 30th of November of 2015. It concerned a site at Brinsey Road in Congresbury. It was an application made in outline for the development of houses, up to 80 of them actually, on land which was not protected by any special landscape designation. Is that correct?
Correct, yes.
Do you have the document
I
to hand?
don't know. I have the second file.
Well, then would you like to take mine? Because the other one is going to need it, not me. It's not for now, anyway. And perhaps Miss Richards could
Thank
get
you.
me another copy in due course. For now, let's just get on with things. So, there's the document. Would you like to tell the inspector what it is he should look at when he comes to interpret the policy in a certain way?
Well, indeed, if I quickly read through that, just to remind myself exactly what that one is saying, but
So sorry, on G1 now.
G1. Oh, hang on a minute.
Brinsey Road, is that the one you have?
Yes, it's all right. I had mine opened up at a different page, which is also Congresbury, but it's Gareth Thomas's decision, so I'll turn to the right one. That's it. There's a few.
Well, there's a number of points within this. If I identify them as I go through the key, as the main paragraphs I've said, Inspector Schofield has identified that the site does not have any appreciable sense of being surrounded by development, which is a point that has been made in this appeal too, that it retains a pastoral character and appearance, and it performs an important function as an area of, and allows for a tangible sense of transition between the elements of landscape that he's identified. And this is a distinctive feature of the village edge, identifying that as the southern setting, providing a strong settlement edge along the ridgeline and emphasizing the elevated position in the landscape.
You probably want to have a look at paragraph 20. Just to move things along a bit. It was agreed that the effect on landscape character in its widest context would be of minor significance. Significant adverse impact in terms of the visibility of the development, which are acknowledged by the appellant, will be limited to the site itself and to the immediate area. This would not, in my judgment, lessen their importance. Right. Is that the part of paragraph 20 you wanted to take us to?
Yeah, absolutely.
Right. Well, okay. Now we need to show that the development was contrary to CS5. So go to paragraph 30, would you? then read it to yourself and tell me when you've read it.
Yeah, read.
Good. So then, having read what was said at paragraph 20, what do we deduce from paragraph 30 as the proper interpretation of CS5?
It is that the development will have an adverse impact on the character and appearance of the area. It's not just the ability of the landscape to absorb the development, that there will be a considerable change to the landscape and visual impact of the area.
Well, we saw at paragraph 20 what was said. We see what's said at paragraph 30. The inspector will join the dots, and I will cross-examine Mr. Wakefield in due course. Thank you for that, Mr. Stevenson. Next, if we could please take up document D1, which is the appellant's statement of case. Do you need that handing up? I think we should give you the box, Mr. Stevenson. Would somebody please give Mr. Stevenson the box? And then he doesn't need to keep being fed. Thank you. You weren't trying to do this technologically, were you, Mr. Stevenson?
That would have probably been easier, if I'm honest.
Paper's always best.
Yeah, I have that here.
Good, that's D1. Now, just to identify the document, we see, if we look at the front cover, it's produced by Ridge, it's the pre-inquiry statement of case dated February 2022. If we turn to page 13 of that document, there's a heading, housing land supply. Towards the top of the page and towards the bottom of the page you see something called the planning balance. Do you see that?
I do, yes.
Good. Right. Have you read this document recently?
I have, yes.
Good. Tell us, please, what other material considerations did the appellant tell us about, bearing in mind their duty to draw to our attention specifically and precisely what it is they wish to pray in aid?
In my reading of this document, they refer to the benefits of housing, but they do not draw my attention to any other material considerations that I would then explore in a statement of case.
No. If we look at 631, the appellant will then identify the benefits of the proposed development, including but not limited to the provision of housing and affordable housing in a sustainable location in the context of an unmet need. But enigmatically, that's it.
Yes.
So when was the first time you were aware of the suggestion that this scheme will deliver precisely 44.2%, I think it is, B&G?
I believe that came in at the time of the exchange of proofs.
Yeah. And when did the council obtain the supporting calculations for that assertion?
That came in after the exchange of proofs. I think it was the 25th of May.
Well, be that as it may, how much weight are you able to ascribe to the precise calculation at this stage, having regard to the fact that this is an outline application in which landscaping is reserved?
Very little. As you say, it is an outline application. We do not know exactly the form of the development, so it's not possible to fully understand how that calculation would be reached on an outline scheme such as this.
Yeah. Well, be that as it may, do you accept that it is probable that the appellant will be able to demonstrate some BNG?
I would accept that as a principle, yes.
Yes. Okay. Well, that's fair. Now, if we then turn up Mr. Wakefield's evidence and we go to the other material considerations that he raises in support of his scheme, I'm not going to ask you to trawl through those material considerations that you've identified and repeat the weight that you ascribe them, because quite frankly, the inspector will have read them. My learned friend has two, and if he disagrees with anything, he'll cross-examine you. But what I would invite you to do, briefly, to the extent that that's possible, is, if we turn to page 21, yes, sorry, 21 of Mr. Wakefield's proof. Section 7, we have the balancing exercise stroke summary of benefits and impacts set out. Yep, that's set out as a sort of text. But if you then turn to table 1 on page 26, there is a helpful tabular presentation of benefits. Now, help me with this, would you? If you look at the conflict with the development plan as a whole, Mr. Wakefield ascribes limited weight to that conflict, which is admitted.
Yes.
Would you ascribe such limited weight? If not, why?
No, I wouldn't. I would attribute great weight to the policies for the reasons that are set out in my proof, that they are in alignment with the MPPF, MPG and so on, and they have been looked at in the other appeals I've mentioned, and they have been given great weight or significant weight at those times.
Yes. I mean, it's not controversial, I don't think, so I'll lead on it, but I'll stand to be corrected. I don't think when I read the appellant's evidence, they allege that any of the policies that are relied upon by the local planning authority are not in accordance with the NPPF. The complaint is there's no 5-year supply, therefore they should be attached less than full weight because the operation of paragraph 11D, if that comes to bite.
That is correct.
I'm not going to take you through your application of the tilted balance, because my learned friend can do that if he wants to set it out in writing. All right. Now, as you look at the other matters set out in this table, actually, do you know what? I'm going to let my learned friend cross-examine you on them, because for me to just drag you through them would strike me as being unhelpful. You set out your own observations in your proof. We don't need to go there. I don't think you just take up time in that way. So, last set of questions from me coming up. If you'd like to just put the proof to one side and take up documents called document E5.
D5, did you say?
Yes, E5.
B5.
To identify it, just to make sure that we're dealing with the same thing, it is the Wardle Armstrong North Somerset Council Landscape Sensitivity Assessment of March 2018.
Yeah, I have that document, yeah.
So, if you would like to turn to map 3, please, which you'll find is on the last page of the document if you ignore the back cover.
Map 3, did you say?
Map 3. You'll see it's map 3 because in the bottom right-hand corner of the page I've taken you to, it says map 3.
Yeah, I've got that.
Can you identify the village of Churchill on that map?
Yes.
Can you identify the appeal site on that?
Yes, you can.
Now, we had a discussion with Mr. Cook and indeed Mr. Sutton about what makes up the village of Churchill. And if I could just ask you to keep your finger on the page which is map 3, but turn to page 41 of the document. So don't lose map 3. But we see under paragraph 6.3.27 the statement, Churchill is a large village located to the south of North Somerset with an estimated population of 1,443. Churchill is split into 3 parts. Recent description, these 3 parts referred to as follows, and by area 1, area 2, area 3. Can I just check with you that if one were to ask the question, in planning policy terms, is Churchill indeed a settlement with 3 nuclei, which is described in this way?
It is, yes.
Yes, so if I looked in the site allocations plan and I tried to identify the settlement boundary for Churchill, it would be 3 separate settlement boundaries.
It would, yes.
But then turning back to the map, if one were to ask the question, are there less sensitive places in which one could develop housing in and around Churchill, according to this document, what would be the answer?
Yes, and there is evidence on the ground that development has taken place in those areas.
Yes. And to the extent that those less sensitive areas are adjacent to the settlement boundaries of the nuclei we are looking at, what would be the policy position if one wanted to develop housing adjacent to the settlement boundary?
In terms of the less sensitive locations?
Yes, that's right. So we have different categories. We've got low sensitivity, medium sensitivity and high sensitivity. We know that the land, that is the appeal site, is ranked as high sensitivity. If one had a low sensitivity or medium sensitivity site adjacent to the settlement boundary, what would be the policy position according to the core strategy?
We'd be looking at policy CS32 as a service village, and that has flexibility within it that would allow for up to 25 adjacent to settlement boundaries.
Yes. So if one were to be advising the appellants where to build in Churchill, what would you tell them?
Not the site that is this appeal site. It would instead to direct towards an area where there is lower sensitivity.
Yes. Now then, last question coming up. Page 19 of your proof, please, paragraph 64. Sorry, which? 64, sir. I beg your pardon. It's page 19, paragraph 64. And we better, while we're at it, pull out document A1, which is the core document, which is the core strategy. So sorry, I missed the first reference. It's my fault. It's page 19, paragraph 64 of Mr. Stevenson's proof. Now, when you get to A1, you're going to need to turn to page 130, where I hope you will find policy CS32? Do you have it?
I do.
Good. Now then, you say paragraph 64, and there are several references to this particular policy. I've just picked 64. But the relevant landscape policy development plan, primarily CS5 and CS32. Yeah. CS32 is the policy I'm particularly interested in applying this case. But CS32 is of a broader application, isn't it? What's its purpose?
It's to allow for appropriate development within service villages, but also at the edges of service villages to address housing numbers and so on. It provides sort of a broad framework for general development management approaches to housing development in these locations.
Yeah, and if I'd have been sensible, I'd have taken to paragraph 43 of your evidence. So just flick to that page, would you?
I have that.
Yeah. Now, you say in the second sentence of paragraph 43, it explains that new development within or adjoining settlement boundaries of service villages, and then you say lots of other things, essentially, provided you meet the criteria that's contained in the policy, it would be policy compliant. Now, does this scheme adjoin a settlement boundary of Churchill?
My starting point was it was, but I did note from the appellant's statement of case that they've referred to policy CS33 as well, which would indicate it doesn't. We've perhaps taken a more pragmatic view to look at this, but...
Well, I just want to be clear, and because it's something I raised in opening, and we just need to nail it. The local authority does not at this inquiry seek to derogate from the applicability of CS32. We're not suggesting, no, you shouldn't use that policy. And just tell us why.
Because it is the policy that would apply. We're talking about development that is adjacent to the settlement boundary, and then it sets out the criteria within that. And in particular for this scheme, bullet points 1 and 4 are the ones that I would identify as key within the assessment of the scheme.
As I read your evidence and Mr. Wakefield's evidence, it struck me that both witnesses have taken the view that, okay, it's on the other side of Front Street, but to that extent it may be regarded as adjacent to the settlement boundary. Is that fair?
Yeah, I think that's a reasonable approach.
Now, do you think, notwithstanding that concession, policy CS33 has applicability in this case? Is it a useful policy to have in mind nonetheless?
It is, yes. Policy CS33 doesn't give allowance for housing in the countryside. It looks to protect the countryside, and it's, for the reasons set out within the policy. There are parts of the site that are separate from the development on Front Street, and the illustrative plan that's come in with the development, to some reading, will actually set it apart from Front Street.
Yeah. So, taking the approach of Mr. Wakefield to apply CS32 and CS33, is that a fair approach in your view?
It is, yeah.
Yeah. Good. All right. Well, in that case, Mr. Stevenson, those are my only questions in chief. You'll now be cross-examined. Sir, I wonder if I might just ask you, could I just have 2 minutes break before Mr. Stevenson's cross-examination starts?
Yeah.
Thank you very much.
So we'll take a short adjournment. We'll adjourn until 10:15. 10:15, the inquiry is resumed. Anything anyone wants to draw to my attention, or we can get straight on?
Straight on, sir.
Mr. Garvey, you may now cross-examine Mr. Stevenson.
Thank you. Good morning, Mr. Stevenson.
Good morning.
So just picking up something that you raised in your evidence in chief, you asked the question, is there anything that you, from your proof of evidence, that you'd like to change, or anything that you think that you've admitted?
No.
Okay, thank you. Let's turn up page 2 of your proof of evidence, if you would, please. So what you provide at paragraph 4 is the putative reason for refusal. I understand it that you were the case officer dealing with this application, is that right?
That's right, yes.
Yeah. Am I right in thinking you never had any direct correspondence at all with the appellant at any stage?
As in during the
application?
We would have done, via email, yes.
Right. There was no discussion of the application, that's right, isn't it?
There was in the email.
Yeah, so you never had a conversation like we're having now, did you?
Oh, sorry.
Either on the phone or in person?
No.
Yeah. Obviously, it was an appeal for non-determination, and the council have provided this reason for refusal. Do I take it that this reason for refusal still encapsulates the relevant policies that you rely upon?
It does, yes.
Right. I'm going to hold you to this, so I need to know exactly what are the policies that the council rely on. So I have it down that it's CS5,
Yes.
CS32,
Yes.
DM3,
Yes.
DM4, 10, and
Yep.
DM32.
Yeah.
And you've mentioned policy CS33 in your evidence in chief,
Yes.
which in fairness is referenced in the statement of common ground as an agreed policy with this conflict. Can I take it that they are the only policies that the inspector and we need to contend with?
In the evidence we've heard so far, there is relevance to policy DM11, which is the AOMB. That was picked up by Mr. Churchill in his evidence, and I think I've also referred to that in the planning balance and how the AOMB is given weight in the balance is in my proof of evidence.
I see a stray reference to DM11 at paragraph 64 of your proof, but I don't see any other reference to DM11. Every other policy you go through, but DM11 you don't.
Sorry, was it?
Yeah, you were saying that you've dealt with DM11 in your planning balance. Where do I see that, sorry?
Just to turn to my evidence there. I will accept that there's no direct reference to it, but in my adoption of Mr. Churchill's evidence, when I've been looking at this in the round, that is where I have been with it. We haven't made the case that harm to the AOMB is a reason in itself, sort of encapsulated in its own area to refuse the application. It's more the fact that that is a matter that is taken into account and is weighed in the balance.
I see. So we can agree then AOMB is not a reason in itself to refuse planning permission?
No, but it does sit alongside the landscape harm that we have identified, and it is a component of that.
I see. At paragraph 37 of your proof of evidence, if you would please.
Yes.
You tell us what the most important policies are for determining the application, and they are those set out in the putative reason for refusal.
Yeah.
Do I take it, therefore, that policy CS33 and policy DM11 we can regard as not amongst the most important policies? And perhaps before you answer, the statement of common ground similarly says the same thing.
I was going to say that that is the position that both parties have taken. What I would say is that CS5 does include an element of protection for the AOMB as well. So that is where sort of I've taken that AOMB approach from.
I understand, but DM11 we can agree is not amongst the most important policies.
It's not, no.
And that presumably reflects the fact that the AOMB is not a reason in and of itself to refuse planning permission.
Yeah, encapsulated in itself, correct.
Yeah, okay.
Yeah, so the development's not in the AOMB.
Yeah, okay. Can I take it that there were no other policies that I need to contend with, or?
No, those are the policies that we have looked at.
Right, so it's the reasons for refusal, CS33 and DM11, albeit DM11 is not one of the most important policies.
Yes.
Thank you. If I were to summarise what are the reasons as to why planning permission should be refused, in broad terms it's landscape and visual harm, it's heritage, either two designated heritage assets, the church and the conservation area.
Yes.
And on landscape, obviously, I take it you defer to the evidence of Mr. Churchill.
I do, yes.
And then heritage, equally, you defer to Dr.
Hudson Macaulay.
I'm so sorry. Dr. Hudson Macaulay. And then finally, conflict with the development plan, and that's where your evidence addresses.
Yeah. Yes.
There's no other issues as to why planning permission should be refused in your mind?
No.
Thank you. And when we're talking about conflict with the development plan, it is setting aside the site-specific impacts, i.e. landscape and heritage, which for the purpose of our discussion, that's been dealt with, and the witnesses have already addressed that. In respect to just pure conflict with the development plan, it's the fact that this is a development which is in excess of the 25 dwelling cap in policy CS32.
As that question is framed, yes, as a point of principle, is the scheme in excess of 32, in excess of the 25 with the flexibility of CS32? Yes, it is.
Yeah, but that's where we're getting to in terms of where that conflict arises from, setting aside heritage and landscape concerns.
Yes, although heritage and landscape are inherent within that, so it's sort of, I'm a bit nervous to say setting it aside because that is sort of within policy CS32 as well. But if you're taking me to the point where the limb of CS32, is it in excess of 25? It is, yes, that is the conflict there.
Yeah, sorry, I'm not trying to muddle you up. What I'm trying to do is divorce your evidence from the other witnesses who've addressed site-specific impacts. So let's turn up policy CS32, if you would then. It's core document A1. And from memory, it's page 130. Yeah, it is 130. Have you got that?
I have, yes.
Thank you. So, in respect to this policy, it allows development within or adjoining settlement boundaries, and I think there's agreement that this is a development which would adjoin the settlement boundary.
It is, yes.
And then there's criteria that need to be satisfied. You rely on points 1 and 4, as I understood it.
Yes.
So I take it as read that the other bullet points in policy CS32 we don't need to concern ourselves with. You would be satisfied that there could be compliance with those bullet points in principle.
That's correct, yes.
Thank you. In terms of 1, which is form, design and scale of development, you'd accept that that is in part related to matters of reserved matters in terms of the scale and design matters that aren't before the inspector?
It is, but insofar that we have a scheme that is a quantum of development of 62 dwellings, so that is a matter that I would be fully taking account of at this stage as well.
Yeah.
I'm not fully taking it, but I'll be mindful of, sorry.
Yeah, I understand that. But to the extent of which whether the proposal does or does not respect and enhance the local character and whatnot, they are entirely matters for Mr. Cook and Mr. Etchell. They are not matters that you address, do you?
I would, when I'm looking at a scheme such as an outline scheme, I would take the advice of people such as Mr. Etchells and Dr. Hudson Macaulay to form my view in it as well. What I would look at is, under this policy and under this particular bullet point as well, we have a site of a certain size in a certain location, and we have a site that the applicant is seeking a quantum of development. So as a matter of judgment, I'd be thinking, well, is it likely that it's going to accord to the principles that are set out here? And that is where I'd have some concerns, which would then transpire to, well, what are these concerns? And it moves towards the issues that have been discussed on landscape and on in the landscape evidence and in the heritage evidence.
Yeah, I promise you, I'm really not trying to catch you out here. Points 1 and 4 in policy CS32, they are to do with site-specific impacts, which you defer to the other witnesses in your team.
Well, when I'm looking at that at an outline scheme, yes, I appreciate the question that when we're looking at those particular matters, those are things that do fall within the reserve matters where a permission to be granted, because then you're looking at the actual shape and form of the development and how it comes forward and what the proposals are.
I'm sure I'm not asking the question clearly enough. Whether there is compliance with bullet point 1 of CS32, the inspector relies on the evidence of Mr. Etchell for the council. He doesn't rely on your evidence on that, in that respect, because you don't address whether this respects and enhances the local character. You defer to Mr. Etchell. So it's not meant to catch you out. It's, as I understood it, you deferred to Mr. Etchell on landscape. That's a bullet point concern with landscape, and therefore it's for Mr. Etchell.
It is a bullet point to do with landscape, but it's also sort of a matter of planning judgment. So I'd take the advice from Mr. Etchells and I'd take his view fully, but I'd also consider that under my own consideration as well.
So I didn't understand this was going to be points between us. What is the bit that, of planning judgment that you make that is outside of what Mr. Etchell is thinking about with bullet point 1?
Well, it's using Mr. Etchell's evidence, it's using Dr. Hudson Macaulay's evidence to understand what are the planning principles, the design principles, if you like, of a scheme of this nature in this location.
Let me try and put it this way. Where Mr. Etchell says this development doesn't respect and enhance the local character, you hear that, you take that advice and go, well, therefore, I take the view that it doesn't comply with bullet point 1. That's what you've done. That's the exercise you've done.
Yes.
Yeah. And similarly, you've done the same exercise with bullet point 4.
Yes.
Yeah. Right. Where your evidence addresses is the fact that this is a site in excess of 25 dwellings, and therefore, as a matter of principle, it has to be contrary to policy CS32. Yeah.
Yes.
Okay. So when we're talking about there being conflict with the development plan, that is principally what your evidence is relating to, this being a proposal which is in excess of the 25 dwelling cap in policy CS32.
It is on that, yes.
Thank you. The tilted balance, it's acknowledged that the council don't have a 5-year housing land supply.
Yeah, that was part of the discussions yesterday, and I think that's also within the statement of common ground.
Thank you. Some points of principle. If we look at page 6 of the framework, please, paragraph 11.
Yeah, I have that.
Thank you. For decision-taking, paragraph 11C, we know that that's where you've got in accordance with an up-to-date development plan. We know that doesn't apply here because there's an agreement that doesn't conform with the development plan. So we turn our attention to 11D, yes?
Yes.
and we are told where there are no relevant development plan policies, or the policies which are most important for determining the application are out of date. And then in footnote 8, we're told that this includes for applications involving the provision of housing, situations where the local planning authority cannot demonstrate a 5-year supply of deliverable housing sites. Yes?
Yes.
Yeah, and we agree that the council are unable to demonstrate a 5-year housing land supply.
Yes.
And the consequence of that is that the most important policies are out of date.
Well, if I am looking at footnote 7 as well, that then brings in the policies that seek to protect areas or assets of particular importance, and that is encapsulated in the evidence of Dr. Hudson Macaulay.
Don't worry, we'll get to that.
Okay.
But you can see that there's a step. Each step of the framework tells us. So the first question is where there are no relevant development plan policies. We know that doesn't apply. Then the next one is all the most important policies for determining the application are out of date. Footnote 8 tells us if the council don't have a 5-year supply, the most important policies are out of date.
Yes.
We agree that the policies in the reason for refusal are those most important policies.
Mm-hmm.
So we can agree, therefore, that those policies in the reason for refusal are out of date.
In that definition, but obviously we'll move on to the weight that we do apply to them under that
Yeah, of course.
position.
Yeah, of course. But as a matter of principle, we agree, therefore, that the most important policies, i.e. the policies in the reason for refusal, are out of date. Footnote 8 tells us that.
Yeah.
Thank you. Then the next step would be to determine whether the policies that protect areas or assets of particular importance provide a clear reason for refusing the development proposed. And as I understand your evidence, it's you rely in respect to the heritage, the harm to heritage assets, and that alone in respect to that providing that clear reason for refusal.
In terms of triggering footnote 7, yes.
Thank you. And again, we entirely rely on Dr. Hudson Macaulay's evidence in that respect.
It is also picked up in the evidence of Mr. Etchell's as well, because there are overlaps of it, but in terms of sort of taking the primary view on that, yes, it's the evidence of Dr. Hudson Macaulay.
Yeah, it's not controversial to say Dr. Hudson Macaulay is the one, as the heritage witness, is the one that we look to provide that heritage harm.
Absolutely. I think what I was trying to say there was that there are elements within Mr. Etchell's assessment that identify that the heritage of this site is of particular sort of landscape character too, so there is an overlap within the two subjects.
Okay, fine. So what the inspector is then required to do on your balance is the inspector is diverted to paragraph 202 of the framework.
Correct, yes.
Because it's a common, well, the council's case is that any harm would be less than substantial and no higher. So the inspector at paragraph 202, you'd agree, would weigh all the public benefits of the proposal and weigh that against the identified heritage harm.
Yes.
And if the inspector found that the public benefits do outweigh that heritage harm, the inspector then applies the tilted balance in 11D2.
In that regard, yes.
Yeah. Thank you. Let's talk about some policies. Whilst we've got the MPPF open, can I just ask you to turn up paragraph 174, please?
Yep.
And it's talking about planning policies and decisions should contribute to and enhance the natural and local environment by, and then under A, it's talking about protecting and enhancing valued landscapes.
Yes.
And then under B, it talks about recognising the intrinsic character and beauty of the countryside.
Mm-hmm.
It's fair, isn't it, that there is a distinction between protecting and enhance, which is what's given to valued landscapes, as opposed to recognising intrinsic character and beauty of the countryside. There is a lower level of protection, the protection is to the valued landscapes. There is a lower level of recognition for those landscapes which are not valued.
Yeah, I'm not entirely sure I fully agree with that. In looking at the first sentence of 174, decisions should contribute and to and enhance the natural and local environment. And so that, for me, sets a test that it's it sort of contribute and enhance. And in doing so, it's recognising the intrinsic character. And that is picked up in the MPPG also.
My simple point is there was less protection given to non-valued landscapes.
Indeed, I mean, there's a whole range of case law in terms of what valued landscapes are, and that isn't necessarily a point that has been raised in this appeal.
Thank you. I'm taking that as you agreed with my proposition, there's less protection to non-valued landscapes. I'm going to talk about policies in the development plan, please. So to that extent, can we turn up core document A1? You can put the framework to one side, thank you. And we're going to look at page 40, please.
Yes, CS5.
Thank you. The policies has three components, as I see it. The first component is about landscape and townscape, in paragraph 1. The second paragraph is about the AONB.
Yeah.
And then the third and fourth paragraphs are about the historic environment.
Yes.
The conclusions on the historic environment flow directly from the evidence on heritage from Dr. Hudson Macaulay and Mr. Sutton, don't they?
They do, yes.
Yeah. So compliance or conflict with that aspect of the policy is dictated by other witnesses. AONB, in terms of that, you can see that this aspect of the policy is protecting development in the AONB.
Yep.
Thank you. So no conflict with that aspect of the policy.
Well, I would pick out in the supporting text for the for that particular element of it, 378, and the significance of the landscape of the Mendip Hills is acknowledged by their designation as an AONB, for which the Mendip Hills AONB management plan has been produced, and the management plan does talk about the setting, and it does talk about views from outside into the AONB.
I understand. Okay. I'll pick up that point with Mr. Wakefield, given it would be common ground, you don't refuse AONB in and of itself. And then the first aspect of CS5 is talking about character and landscape and townscape. Now, there's a point of divergence between the parties as to what extent you factor in visual harm here.
Yeah.
Mr. Wakefield, let's put it this way, Mr. Wakefield does acknowledge, as Mr. Cook does, that there is visual harm to the development proposal.
They do, yes.
Yeah. That clearly goes into their planning balance as a material consideration.
I'm not entirely sure it does. Can I turn to the table 1 of Mr. Wakefield's evidence, just to remind myself?
It is there, but we can turn it up if you'd like. So, his proof of evidence, page 26.
Yeah, visual harm to the landscape, and that's set as moderate in that table, yes.
So it's fair Mr. Wakefield does factor that into his assessment of what the material considerations.
Yes.
Yeah. Similarly, no matter what the end interpretation of this point is, it's common ground that there's conflict with the development plan as a whole.
Correct, yes.
So in reality, it doesn't actually make that much difference, does it, whether the moderate harm to the moderate visual harm leads to a conflict with policy CS5, because either way, that harm goes into the planning balance, and either way, there is conflict with the development plan as a whole.
Well, I think as we've heard from Mr. Etchells, he would disagree that the extent of visual harm is moderate. He's, through his evidence, he's made a very strong case that it's actually considerably more than that, and would is to a level of, well, unacceptable level of harm that would merit refusal of the planning application on those grounds too.
Sorry, yeah, I promise you, at no point today will I try and ask you to try and cut across the evidence of Dr. Hudson Macaulay or Mr. Etchell's. That's their evidence. You've taken it on face value. Or I'm asking you a different point. It's the interpretation of the policy point. I'm trying to say there's an interpretation point as to whether you do or do not factor in visual harm as leading to conflict with this policy. What I'm trying to get to is, where does that really get us to? Because on either interpretation, you still have to factor that visual harm, whatever scale it is, into your planning balance.
Yeah.
Whether it's significant or whether it's moderate, it's still in the balance. And on either view, you still have conflict with the development plan as a whole.
Correct, yeah.
So in reality, the interpretation point between us doesn't really help us determine the appeal, does it?
Framed in that way, perhaps so, but it's, obviously the evidence is quite considerably apart of where we are at the appeal.
Yeah, the scale of harm, I'm completely with you, but in terms of the interpretation point, it's a relatively academic point, isn't it?
It is.
Yeah, thank you. The next point I'd like to talk to you about then is policy CS32. I know we've canvassed it somewhat, but I just want to pick up some residual points. So back to page 130 in this document, please. Sorry, just give me a nod when you've got the policy.
Oh, sorry, yeah.
Yeah, thank you. Having the policy to one side, I want to look at what you say about it in your proof of evidence, please. So you'll probably want to have your proof and potentially the policy in front of you, if you wouldn't mind. And we're going to paragraph 46, please, within the proof.
Yeah, I have paragraph 46.
You rely, paragraph 46, on the significant degree of flexibility afforded to, that's provided through this policy.
Yes.
And obviously, that degree of flexibility needs to be judged in the context of, well, what proposals have been granted in accordance with this policy.
My intention in framing it with in paragraph 46 is set out in the dealing with the quantum of development, in that previous version of CS32 before the policy was remitted was much more clear. That said development outside the settlement boundary needs to be an allocated site, so there was no flexibility within that. Apologies, I can't remember the name of the inspector that dealt with the remitted policies, but they came back and then is put in there that there's this flexibility that says outside settlement boundaries up to about 25 to allow small amounts of growth at service villages.
Yeah, the strategy, as far as this core strategy is determined, is, well, we'll have a degree of flexibility by letting you have up to 25 dwellings outside settlement boundaries.
Correct, yeah.
And we know there are consequent policies that talk about it being 50 outside settlement boundaries. And we've heard in this inquiry of two such sites, one for 25 and one for 50. Yeah.
Yeah.
So the inspector will look at that degree of flexibility that's encapsulated in this policy through what proposals have actually been granted through that.
Yeah, those others we've referred to, where we've looked at schemes that are compliant with policy 32, service villages, that's been up to about 25. I think the other ones you referred to were sites at Nailsea, which is policy CS31, where there is a, in line with the settlement hierarchy and the spatial strategy of the plan, there is a greater number allowed at those sites because of their higher order, and then likewise the Western Supermare policy allows up to 75, I believe it is again. So sort of it sets that hierarchy. So in my paragraph 46, I'm recognising that you can develop outside a settlement boundary and still be in accordance with the policy, But in the whole, in my evidence, I said, well, actually, the quantum at 62 doesn't accord to that. So as a point of principle, it's in conflict with CS32.
Yeah, obviously. We don't demur from that. That's agreed in the statement of common ground. And obviously 62 is greater than 25. My point was we've heard about 2 such sites that have been granted pursuant to this degree of flexibility.
And these were the sites mentioned yesterday at Nailsea.
We don't get, and the witness has said this, 50 unit site was not at a service village. So if it's being put that you can do that on the CS32, that is not a...
I don't think that's...
I'm aware of the
Yeah,
distinctions between the different levels, but if you...
Thank you. I'm saying this degree of flexibility, where one policies which allow for 25, for 50 or 75, we've been told about 2 proposals, one for 25, one for 50.
Yeah.
Thank you. And then paragraph 47 of your proof of evidence, please. And you tell us there that if the tilted balance, or at least as I understand what you're telling us here, if the tilted balance is engaged, the reference in CS32 to sites in excess of about 25 dwellings having to be brought forward as allocations through the local plan process could be afforded less weight if the most important policies for determining the application are deemed to be out of date. Now, we agree that the most important policies, including CS32, are out of date. Therefore, it must follow, given what you say in your proof, that the inspector can afford less weight to policy CS32.
Less weight to the limb that says up to about 25. The purpose of my paragraph 47 is to acknowledge that if there isn't a 5-year housing land supply, then it is a more difficult argument to make to say that a scheme of 25 is contrary to CS32. Sorry, I might have lost my train of thought a little bit there.
Well, that's fine. Let me help you, because I don't actually think we're repeating back to you what you say in your proof, which is, given we agree that the council don't have a 5 supply, which renders the most important policies out of date, which includes policy CS32, you tell us that you should therefore afford less weight to this cap on 25 dwellings in the policy.
Yes, when you're just looking at that cap of 25.
Thank you.
But the difference is the schemes we were talking about yesterday at the main towns still followed the numbers within policy CS31 in those instances. So the development at Nailsea, for example, was still in accordance with the numbers set out within CS31.
Yeah, we don't dispute that you've had 2 sites granted pursuant to this flexible policy. It's not an issue that we see fit to dispute. Okay, core document A2, please. We're just going to carry on this thread and just go through the rest of the relevant policies, please.
I have that, yes.
Thank you. We're going to go through them in order. So DM3, which is page 12, if you would, please.
Sorry, where did you take us to then?
Sorry, sir. We're in DM3, which is core document A2, and it's page 13.
Thank you.
I have that, yes.
Thank you. This is the conservation area policy. I'd be right in saying that the application interpretation of this policy flows entirely from what Dr. Hudson-McCauley says.
Yes.
Yeah. Thank you. So as far as your evidence is concerned, it's not something that we need to concern ourselves with. It's, if the inspector finds there is harm to the conservation area, there seemingly is some consequent conflict with this policy.
Yeah, that is the case.
Thank you. The next policy, therefore, DM4, page 15.
Yeah.
Again, same point with the listed building.
Yes.
Yeah, flows entirely from the evidence, Dr. Hudson-McCauley, as far as you're concerned.
Yeah.
DM10, page 28, if you would, please.
Yes.
Now, this policy is dealing with landscape character. And again, we find ourselves in that same element of dispute between, well, do you factor in visual harm in the interpretation of this policy? But I hope you'd agree with me, as we agreed in respect to policy as CS5, it's ultimately an academic debate.
Well, I'd say that you do factor in visual harm, same as with CS5, yes.
Yeah, I know.
Yeah,
There's a point of divergence. Do you bring in visual harm? But as we agreed earlier with policy CS5, whether you do or don't, you actually get to the same end result. You still have conflict with the development plan as a whole, and you still have to factor in that visual harm as a material consideration, come what may.
Yes.
So it doesn't actually make that much difference. It's a relatively academic question.
yeah.
Yeah, thank you. But we can note, in respect to landscape character, just at the last paragraph of the policy, it's not saying you can have no adverse impact to landscape character, because you can see it says where some harm to local landscape character is unavoidable, but a development is otherwise deemed beneficial, then positive mitigation measures should be secured.
It does say that, yes.
And the first bullet point in the policy is talking about not having an unacceptable adverse impact as opposed to having no adverse impact.
Well, that's the point, that the test is that there's no unacceptable adverse impact, which is the council's case that there is an unacceptable adverse impact.
Yeah, as I said, I'm not going to invite you at any point to try and cut across the evidence of Mr. Churchill's. I'm not trying to catch you out. I'm just trying to understand what flows from this policy. Is not. There are some policies that say no adverse landscape impact, and they are sometimes branded as nil detriment policies.
Yeah.
Any level of harm leads to conflict. This is not one of those policies, because it's talking about having an unacceptable adverse. And the second bullet point, see the very end of that second bullet point, it's talking about while minimising landscape impact. See that?
It does, yeah. I mean, sort of going back to that final paragraph where it says some, for me it's a much lower test, it's a much lower bar. It's kind of inevitable that putting housing in a greenfield site would result in some landscape harm. It would change it from, say, a pastoral landscape to a built environment. So that's what I'm looking at in terms of some. So what the policy is telling me to do is to sort of seek measures to mitigate against that. What I'm saying here is that we've long since departed from that point of some. It's unacceptable. So I'm not trying to sort of find landscape mitigation that would therefore make it acceptable. It's, for my mind, it's not going to happen that way.
Thank you. We'll keep on going with the policies in a moment, but I just want to pick at that thread that you said that it's, your words, it's kind of inevitable having some landscape harm putting housing in a greenfield site.
In so much as that if you have a greenfield and you put one house in it, there is a change. Obviously, sort of, it's site-specific how much that is harmful or not, and with a hypothetical situation of one dwelling, maybe not so. I need to tread carefully here because I'm aware that there are a number of appeals for land around Front Street and so on, where inspectors have found harm, and those are referred to in the court documents, but for the purposes of this policy, I don't think that's the point I'm making there.
It's just, it's an interesting point, which is, you're saying, well, it's inevitable if you put housing on if you put 62 dwellings on any greenfield site, seemingly you're going to have some degree of landscape harm, as I understood, as a matter of principle. The extent of that harm is judged on the site based on site-specific issues and applying the relevant criteria and whatnot. That being the case, you heard yesterday from Mrs. Richards that the council will inevitably have to develop sites, greenfield sites, outside of settlement boundaries to be able to get back to a 5-year supply. Do you recall hearing that?
Yes, that's what we're aware of, yeah.
Yeah, so inevitably, there is going to have to be some landscape harm in order for the council to get the housing?
It is, but that would draw back to a point that Mr. Leader took me to in Chief about where would you develop, and looking at the Wardle-Armstrong sensitivity thing. If you're looking at landscape harm, it's quite sensible that you look at areas where it's of a lower sensitivity rather than high sensitivity, which this site is.
We'll come on to this point about alternative sites, don't worry. But you agree with my proposition, don't you, that the council are inevitably going to have some landscape harm in order to restore having a 5-year housing land supply? Because that has to flow from what you've said, because you're saying greenfield sites involve landscape harm, and Mrs. Richards said, well, you need greenfield sites.
Yeah, I'm talking in the round there in agreeing with you that, not necessarily talking about this particular site, but the other sites that have come forward, may come forward, there is a degree of landscape harm. I mean, there's an application that has been mentioned many times over the last few days, which is Dinghurst Road. There is an element of landscape harm within that, but that's being gauged at lower than this particular site because of the site context and where that particular site is and how it sort of interacts.
That's the site where there was moderate landscape harm, is that right?
Off the top of my head, I couldn't tell you yes or no on that.
Fine. I'm so sorry to push this, but just, you've given me various counter-arguments. I can take it as read. You agree with my proposition, though. It's inevitable that the council will have some landscape harm in order to restore their 5-year housing land supply.
Yes.
Thank you. The next policy I'd like to talk about then, keeping this thread, let's go to policy DM11 on page 30.
Yeah, I have that.
Again, it's a policy not in the reason for refusal, but notwithstanding that, let's look at what the policy deals with. The second paragraph of the policy says, development which would have an adverse impact on the landscape, setting and scenic beauty of the Mendip Hills A and B, including views into and out of the A and B, will not be permitted unless in exceptional circumstances and where it can be demonstrated that it is in the public interest.
Yes.
Now, that introduces an exceptional circumstances test, irrespective of whether the development is major development, doesn't it?
It does, yes.
Yeah, which would be in conflict with the MPPF, because the MPPF only seeks to only imposes this exceptional circumstances test in the A and B, where it's major development.
So I'm just rereading that paragraph to get my mind in place on that. Sorry, yes, and the question was, does that align with the MPPF, wasn't it?
Yeah, because the MPPF, and I'm not trying to, if you want me to take you to the policy in the MPPF, I'm more than happy to.
I will do, just so...
of course, it's 177 on page 51.
Yes, I have that.
Yeah, so you can see that 177 is dealing with when you've got development in the A and B, it should be refused for major development other than exceptional circumstances.
It is, but that's development within the AONB. We've got a site that's not in the AONB. That's in the that's a point of fact, isn't it? So we're not saying it's in the AONB and it's we need to look at this under exceptional circumstances. That's not sort of where we've gone with it.
Right. So we can agree, therefore, that the inspector need not find exceptional circumstances in order to find compliance or otherwise with policy DM11.
Well, no, because we're not in the AONB where you've drawn my reference to 177. So it's not a route I would go down because we're outside the AONB. And then I've sort of looked at the, or Mr. Etchells more particularly has looked then at the issue of the setting of the AONB and why that's of relevance and what in sort of reference back to the management plan and the other points that he's raised in his evidence.
Thank you, that's helpful. But coming back to my point, it's still the case, though, that policy DM11 does not transpose the major development threshold from national policy, does it?
No.
So in that respect, it is inconsistent with the NPPF.
Or in that respect, yeah.
In the week, sir, about policies being consistent or inconsistent with the NPPF and this not being the appellant's case. If this point's going to be put, it's not proper. If my learned friend wants to develop an argument that the policies of the development plan are not consistent with the framework, that should have been set out in the proofs of evidence.
I'm so sorry, that is an entirely unfair point when this is not a policy in the reason for refusal.
I'm ever so sorry to say this, but Mr. Wakefield talks at length about policy DM11.
He doesn't mention it. He mentions the policies and the reason for refusal.
Mr. Wakefield, as I will show you, does deal with policy DM11 and he does not assert that it is contrary to the NPPF. And if you want me to take to the relevant parts of his proof, I will do so.
I think it's unfair for the council to not include a policy in the reason for refusal and then criticise us, sir, for not having advanced a proposition about it.
Okay. Well, you've heard the objection. Proceed with the questioning with that in mind. I'm not sure how much more information I need as to how to assess the effects on the AONB sort of anyway, based on what I've heard so far. Just bear that in mind.
Well, that's very helpful, sir. Well, in that case, I'll move on and say nothing more on the point. And I'll move on to DM32 in that case, sir. And we're going to page 76, if you would, please.
Yeah, I have that.
Just on policy DM32, this is a high-quality design and placemaking policy.
That's how it's titled, yes.
Yeah, and you can see that from the opening text of the policy, it's talking about the design of new development.
Yes.
And equally the second paragraph, the design and planning of development proposals. Would I be fair in saying that this is a policy which in reality is directed towards the issues that are relevant to the question of reserve matters, where we do deal with appearance, scale, landscape and whatnot? It's not a policy which is particularly relevant to this development proposal being in outline form.
It's kind of and kind of not in a way. Yes, I get the point that those are, when I'm looking at a reserve matters submission, those are all points that are at the fore, and those are there. The question for me is much more, is the design and planning of the development, is it sensitive to the local character? Now that's I'm loath to say sort of point of principle, but it's about putting 62 dwellings in this location, and so there, with that in mind, DM32 is something that I'm taking into account, because I'm saying, well, on the evidence of the others and also my own judgment, is a scheme of this quantum sensitive to the local character, and for the reasons in all the various evidence, it's not. So that's how I'd use 32 in this case.
Right, thank you very much. Let's pick up this point that you make about there being other sites. Take me to the evidence that demonstrates that there are better alternative available sites.
Well, that's not a test that is in any of the policies, so that's not one we have to. It is, when I was referring to that, that's much more sort of applications that may have come my way or sort of submitted to the council. Essentially getting to the point that there will be some sites that are of lower sensitivity and therefore, for their own reasons, are more likely to grant approval based on circumstances of those sites, whereas this site is of high sensitivity. So it's, of all the places that have been developed in Churchill, and there are sort of Pudding Pie Lane, there's a site that's being built out there, and one that is has an outline consent as well, Says Lane, Bristol Road, and so on, and now Dinghurst. They are different to this site, and sort of the point that runs through my mind is if we're looking at allowing for development in Churchill as CS32 will permit, this is probably like one of the last sites I would look at and say, well, actually, no, because of the context of this site, it's not going to be one that we'd want at all. It's sort of bottom of the pile, if you were.
Would you like having a go at answering my question?
Sorry, where's the evidence of that?
Yeah.
There's not any in the council submissions because that's not a test that the policy has asked us to do. We're not set out to say these are all the sites. That's in.
Yeah, you're quite right. The development, the appellant need not meet any test that there are better alternatives, and there's ample case law on that, which we need not trouble you with because it's matters of law. But it's often said by local planning authorities there are better places to develop. And the contention is, well, if there were better places that are available, why don't the council have a 5-year housing land supply?
Well, that's not what we've said here. We haven't said there are better places. We've said this site is unacceptable. We haven't then gone on to say, but that's not as we've put it.
Right, well, I misunderstood your evidence in chief in that case. If you're not saying that there are better alternative sites, then I need not trouble the inspector with that point further.
By definition, there are, because we've refused this site and we may approve other sites, but it's not evidence for this inquiry.
Okay, I think I understand that. By definition, you're saying there are better sites, but you've got no evidence before the inquiry of that proposition, and because you didn't think you needed to advance that point.
Yep.
Fine. The emerging plan, we agree that the emerging local plan can only be afforded no more than very limited weight.
Correct, yes.
There's no part of your case is there to suggest that Churchill doesn't have capacity to absorb 62 further dwellings, is there? As a matter of principle, setting aside site-specific adverse impacts.
No, those words are not in my case.
Yeah. And we agree that the development proposal would be accessible from services, facilities and employment provision, don't we?
It is. In some ways, it takes me back to that sort of previous point where we've allowed development within Churchill, and this has been taken to in evidence in chief as well. Churchill has its 3 elements, but you take that as a settlement as a whole. Where other developments have taken place, they have been, if you like, sort of much more accessible to sort of everyday services, facilities that you would go through on that sort of sustainable point. We haven't made the point that Front Street is. It's next to the school and so on like that, but where the other sites have been, close to the facilities that are such as the primary school, the shops, the services, the bus links along the A38, the GP surgery, the recreation ground, all those sort of things that are there. They're much more accessible in terms of sort of walking, cycling routes. Front Street does have flaws in that travelling from, hypothetically, from the appeal site to those services, you have to go along Front Street itself, which has been said in comments from the local residents as well, who have particular knowledge of it, that it is a dangerous route.
Can I interject? Because we're potentially going down a dangerous route here, and I wanted to try and see if we are. Can I invite you to turn to the statement of common ground, please? We're going to page 12, please.
Yep.
Highways and transport, do you see that?
I do, yes.
The site is accessible to nearby services and facilities and employment, including local bus services. You're not going behind that now, are you?
No, I'm just saying that it just about meets those. We haven't put that in the reason for refusal. I do acknowledge that, but equally I'm not going to say, well, yeah, this site is the same as the others in Churchill in terms of that assessment, but we've not gone there.
Okay. I'm going to take it that the statement of common ground stands as is, and I don't need to worry about those sorts of issues.
Yes, I'll leave the inspector to pick up from his thoughts from what the local residents have said on that point of view. It's not the council's case.
Yeah.
You can assume and proceed on the basis that when we agreed things and stepped to common ground, we intended that they should remain agreed, so you don't need to cross-examine, if that helps.
Do you want to?
Okay. Do you have a copy, please, of the additional inquiry documents that have been passed up? One that was handed up yesterday, thank you.
I do.
And this one that was handed up, I think, at the very end of last week.
I don't have a copy of that to hand. Could you...
Choices for the future is the... Oh, thank you very much.
Is that goes with that, does it? Oh, yes, thank you. Yes, I have those documents.
Thank you. So we're going to talk about the constraints facing the local planning authority. So we can see that this choices for the future is part of the consultation in November 2020.
Yes.
This formed part of the issues and options for the emerging local plan.
Yes.
And you can see in respect to the constraints of development, we've provided extracts, but you can see that it said that some constraints mean that certain areas are unsuitable for development. Can you see where I'm reading from?
This is in the green document effect, isn't it?
Yes, sorry.
Yeah. And sort of that page.
Yes, thank you.
Yeah.
And it said that these include, for example, floodplain, nature reserves, or ancient woodland.
Yes.
And other constraints don't completely rule out development. This plan shows three key constraints in North Somerset, which cover the majority of the district: the Greenbelt, Flood Zone 3, and Mendip Hills AO and B.
Yes.
And you can see, somewhat crudely, it's shown the broad areas where the floodplain, Greenbelt, and AO and B encapsulates.
Yeah, I have that here.
And it's fair to say, when it's said that the majority of the district, those constraints cover a huge amount of the district, don't they?
They do, yes.
Yeah. And we can see on the next page, which again is page 16, that we're told in respect to the Greenbelt, that second sentence, Greenbelt covers about 40% of North Somerset, generally between Bristol and the edges of Clevedon, Nailsea and Yatton.
Mm-hmm.
And it goes on to talk about, in the second column, it says, given Greenbelt and flooding constraints, there's very little growth potential proposed at Clevedon and Portishead. You with me still?
Yes. Mm-hmm.
And then we can see in the final paragraph, it says that it should not be possible to meet fully the housing needs in a sustainable locations. There will also be an opportunity to consider growth in neighbouring authority at Burnham-on-Sea. There is an option identified in the Sedgemoor local plan. And we know that the Greenbelt, the local planning authority, as things stand, are proposing to put development in the Greenbelt, aren't they?
Yes.
Yeah. And the reason why the local planning authority is proposing to put development in the Greenbelt is because housing need. And we can see that from core document K3, if you wouldn't mind turning that up.
I have that, yes.
Thank you. You can see this is talking locational policy. This is in the preferred options, locational policy LP8. Do you see where that is?
Yes, I do.
Thank you. And do you see under the justification?
Sorry, what are we looking at now?
I'm so sorry. This is the preferred options for the emerging local plan. It's core document K3, sir.
K3, yep.
And it's talking about the extent of the Greenbelt, because as things stand, the council are proposing to change the boundaries of the Greenbelt.
Sorry, is that?
Yeah, that's right, isn't it?
It's in the preferred options, so that is something that's being looked at. I'm not actually directly involved in the formation of policy, so I'm a little loath to say definitely yes, definitely no, but it's what I would gather from the preferred options document.
Yeah, fair enough. Under the justification for this policy, can you just look in this final column where it says changes to the boundary at Yanley Lane? Can you see where I'm reading from? Mm-hmm. Woodspring Golf Course, Backwell and Portishead are a result of exceptional circumstances resulting from the need to accommodate the housing requirement.
I do, yeah.
Yeah. So the local planning authority, as part of the preferred options for the emerging local plan, have acknowledged that because of the need to accommodate housing, they're going to have to go into the Greenbelt, and the exceptional circumstances are made out, yes?
Well, that's one of the options that's being looked at, yeah.
Yeah. Just to help you, this is not one of the options that the council are mooting. This is the option that the council are, at the moment, suggesting that they're going to really be advancing. That's what they've consulted on.
As per that document, yeah.
Yeah, thank you. So as things stand, the local planning authority's view, as we sit here today, on what they need to do with the emerging local plan, is they're going to have to go into the Greenbelt because their housing need is such that they've got to go into these constrained areas and exceptional circumstances are made out.
That's on the table, yes.
Yeah. And finally, I'd just like to look at this document, please. It's the other preferred options handed up yesterday afternoon.
So this is an extract of the same document.
That's right, sir. Not that one. Yeah, but it's this is the same as K3. Yeah.
This document.
Yeah. Oh, if you've got the full one, we're going to page 15.
Yeah, I have that.
Thank you. And this is SP8.
Mm-hmm.
And you can see that it says land will be identified to secure the delivery of a minimum of 20,085 dwellings
Yes,
within North Somerset. We know because of changes to the standard method, and Mr. Richards agreed that the figure has now gone up to 20,883 dwellings.
Okay, yeah, I'll take your word on that.
If you're unclear on that, it's Mrs. Richards is nodding, so I think that was a point of common ground yesterday. And we can see that what the council, so they need to hit the figure of 2883, and you can see that there's a total figure of 18,046.
Yes.
Yeah, so there's a shortfall of roughly 2,850 that the council will need to find.
Yeah, so we're sort of 90% of the way there at the moment.
Yeah, well, 86% because of the increase in 800 units. But as part of this preferred options, the council are looking at, well, where are we going to find these additional 2,850 units?
Yeah.
Yeah. So there is already an intention to put more housing in several locations, villages, including Churchill, and the council still need to find an additional 2,850 units.
It does, yeah.
Yeah, thank you. On the point of Greenbelt, the fact that the local planning authority are proposing development in the Greenbelt because of their housing requirement suggests, doesn't it, that there is a shortage of sites outside of the Greenbelt to accommodate the council's housing requirement.
Well, as I said before, I've not been directly involved in the formation of policy. It's not particularly my area. What I would point out is that this is a...
It is a fair point with these questions, in that Mr. Stevenson's sort of not prepared these documents. He's not referred to them in his evidence as well. So just bear that in mind with you, with the questioning.
Yeah.
If I may, I've been sitting here quietly thinking to myself, I wonder to what extent Mr. Wakefield trailed all these points, and the answer is not at all, really, which is why the document's been handed in during the course of the inquiry. So Mr. Stevenson has said he doesn't have involvement in preparing the plan, and he doesn't. And I had understood my learner friend's case to be that little weight should be attached to the local plan as a draft anyway. So if that is his position, one wonders what the point of all this is, because if he thinks there's little weight to be adopted to part of the plan, presumably it should be applied to all of the plan. I do take objection to it being put to my witness in this way when on his own case little weight should be afforded to the document.
Well, it is in the core documents as K3. You know, proceed, but just bear that in mind.
So your point's a very fair one. It's not appropriate to ask this witness to give the council's formal position on a document he's not prepared. I understand that. I was asking the witness just to interpret the document as we read it, as just an objective lens. But so I can pick that with Mr. Wakefield.
No, I'm not saying I'm not saying you can't do that, but just bear in mind, in the interest of fairness, of what is in Mr. Stevenson's evidence as well.
Yeah. So I'll ask one final question on this point. I should say this point is canvassed in Mr. Wakefield's proof, so we will pick it up when we come to his evidence in chief. But the final point I just wanted to canvass with this witness, if you'll allow me one more point on it.
But I'm not stopping you at all. There's no way am I stopping you. So carry on.
Thank you, sir.
Sorry to interrupt.
No. It's helpful, sir, because I was about to make that caveat. It seems like this witness hasn't prepared it, so he can't give the council's formal position. I was just simply taking it as a matter of principle, taking yourself away from this local planning authority just as a matter of principle, where you've got a local planning authority proposing to put development in the Greenbelt because of housing need, and that's what makes the exceptional circumstances. That would suggest there's a shortage of sites outside the Greenbelt, as a matter of principle.
It could amongst other arguments, though. I'm not necessarily sure I'm informed enough about that point to say yes or no. I mean, yes, it would indicate, but we're not, that's not part of my evidence. It's not something that we've gone to.
Okay, fine. Let's turn up the Hallam Land judgment. Now, I'm always reluctant asking about legal judgments with witnesses. So is this a judgment? We've canvassed it in the inquiry, but is it a judgment you're in any way familiar with? Or the paragraphs we've looked at in the inquiry, are you come to asking questions about them? You can get a free pass, because I don't like cross-examining witnesses on legal judgments.
Which document is one of the...
It's core document G44.
I know the name of the appeal, I know it's referenced, it's talked about, but it's just check my own familiarity with it. The decision in terms of the extent of a 5-year land supply shortfall and how that is considered.
Yeah, that's I don't recall whether you were here for Mr. Tiley's cross-examination yesterday.
I wasn't, no.
Right, okay, that explains it. We discussed the judgment at some length yesterday. As I said, you can have a free pass, and there's nothing to be gained. I don't typically cross-examine on legal judgments, but just given we've canvassed this judgment to some length, I wasn't sure whether you're familiar with it.
I'm not entirely sure how much I will assist you on this, because I'm aware of it, but my familiarity is not overly strong, if you like. So,
well, let me...
So no, is the answer. No, I don't know enough about it to to go there.
Well, I think that probably answers my question. I'm not going to make anything of that. I'll just pick it up with Mr. Wakefield in that case. Do you agree with this, that the housing shortfall informs the weights to the benefits and disbenefits of a development proposal?
It can do, yes.
Yeah. When there was seemingly a point made about the appellant's statement of case in the evidence of chiefs that there's an absence of references to benefits. Just to that end, can I ask you, I'm not going to talk about Hallam Land in greater extent, given you're not familiar with the judgment. I'm going to ask you about the benefits of the proposal. To do that, we're going to pick up core document C11, please.
Yeah, I have that. Which page?
We're going to page 41, please.
Yeah.
And you can see at paragraph 7.73.
Yeah, I do, yeah.
Yeah, it's talking about the public benefits of the scheme.
Mm-hmm.
And these would have been the public benefits that when you were looking at the application, you would have been having, presumably you would have been looking at some of these benefits.
When I was looking at the application, and particularly as is mentioned in the statement of case, what was put to me was that the public benefits were the delivery of housing, affordable and market housing.
The statement of case says including but not limited to.
But it doesn't say any of the others though. So I just sort of took that and went with that and thought, okay, the point being made to me is I'm asked to look at the benefits of housing. There was an opportunity there to add in the others, but they weren't within it.
Right, so these benefits that are being advanced as part of the application, are you saying that you didn't have regard for them?
No, I did, and that's set out in my proof of evidence in my balancing exercise.
Okay, well let's turn to your balancing exercise then, and let's consider that. Tell me where in your proof of evidence you acknowledge that the council do not have a 5-year housing land supply.
Well, at the time that that was being prepared, the position was that we did. I think there is a line in there that says we will obviously reserve that position, and I think that was what been discussed obviously at length yesterday in the subsequent appeal decisions. I think the Moore Road appeal decision in Yatton was the one that sort of addresses that as a point in my evidence.
Yeah, my first question to you this morning was, is there anything you want to change in your proof of evidence? And you said no. So it is surprising, to say the least, that a significant material consideration, the council not having a 5-year housing land supply, in your evidence, there is no acknowledgement of it, no acknowledgement in your evidence in chief, no acknowledgement of it in your proof of evidence.
Apologies, yes. Yeah, I've sort of taken the discussions that have taken place in the inquiry subsequently as read. I kind of overlooked that, as it were. Yeah, that's fair. That's how I read your proof, that you'd overlooked that point. And similarly, you've overlooked the fact that there is a planned period shortfall. There's, again, no acknowledgement of that point in your proof of evidence. Because that wasn't in the statement of case from the appellant either. They've never made that argument, so I didn't go there with that one.
Right, okay. We say that the local planning authority, well, actually it's common ground that the council do have a planned period shortfall, so that the housing requirements set out in the development plan will not be met. That being the case, we say that the strategy in the development plan has failed because it has failed to deliver the minimum housing requirements set out in the core strategy. Do you agree with that?
Well, that's looking at the housing figures.
I mean, Mrs. Richards, I don't know whether you were there, it was acknowledged and agreed.
Yeah, I acknowledge that, yeah.
I'm not taking evidence that you're not. It was agreed the council will not meet its minimum housing requirement, even assuming the council's figures on delivery are correct.
Yeah.
So that being the case, and you defer to Ms Richards on that point, we say the consequence of that is the strategy has failed because the strategy was intended to deliver a minimum, and we know now that that minimum will not be met.
Okay, yeah.
Do you agree there that the strategy has failed?
In terms of the numbers, yes.
Yeah. And that must have a weight on, and some bearing on the weight that you attach to conflict with the development plan.
Indeed, yeah.
Yeah. And again, it's fair, at no point in your evidence do you acknowledge that, but I presume that's because Ms Richards hadn't acknowledged that point when you came to write your proof of
Well,
evidence.
but that's an unfair point, because he's just agreed with my witness that it was Miss Richards' concession, and Mr Stevenson's told us he wasn't here yesterday.
I'll take from it what I need to. But if you just carry on.
Thank you very much. In your proof, in terms of the weight that you attach to benefits, at paragraph 107, if you would, please.
Yeah.
So you attach significant weight. You attach significant weight to market and affordable, seemingly combined.
Mm-hmm.
Would you say it's fair to actually say that you attach significant weight to each of them as individual benefits? Because the need for market and the need for affordable aren't entirely the same.
No. There has been talk on the housing needs with affordable housing yesterday. I don't have the figures in front of me about the numbers of affordable units that have been delivered in Churchill, say, and where exactly the local need sits. I acknowledge that as a district or as an authority there is a pressing need to deliver affordable housing. The question is that pressing need particularly in Churchill at the moment? Well, you could come back to me and say, well, it's everywhere, isn't it? But there have been, with the developments that have taken place in Churchill, there's been considerable delivery sort of pro rata with those numbers.
Sorry, my question was, it's fair to give separate weight scales to market as one benefit and affordable as another. That's fair, isn't it?
Yeah, when you're looking at housing, both will carry significant weight, yeah.
Yeah. You said it carried significant weight when the council did have a 5-year housing land supply. We now know that the council don't have a 5-year housing land supply. Presumably, it must have more than significant weight. Indeed, Mr. Leader referenced substantial weight in his opening. Presumably, that's acknowledgement that you give even greater weight than you originally envisaged.
It is, yes, and the obviously the extent of a shortfall is something that is put in that case. Yeah.
Thank you. 108 of your proof, you deal with economic benefits and you afford that limited weight. Can I ask you to turn up paragraph 81 of the framework, if you would, please?
I have that, yes.
I'm so sorry, just those taking notes. I take it that we're giving substantial weight to each market and affordable.
We are, yeah.
Thank you. So back to economic. Paragraph 81 of the framework, please. You can see in the second sentence that tells us that we give significant weight should be placed on the need to support economic growth and productivity.
It does say that, yeah.
Yeah, so we're mandated by policy that we don't give a limited weight to economic benefits. We give significant weight.
We are, yeah.
Yeah, so where I read in paragraph 108 of your proof of evidence, you give them limited weight, can we correct that to significant weight?
Well, no, but the way I'm looking at that one is those, I mean, we're talking about what would flow from the development. Construction jobs, yes, but then that is limited in time. So that is, over the lifetime of the development, it's going to carry less weight.
Let me pick up two appeal decisions that deal with paragraph 81, and then you can see what your resolved view is on this point. So, core document G20, please.
Yeah, which paragraph would we go to?
We're going to page 11, please, and it's paragraph 59.
Okay, yeah,
You've read that, have you?
I have, yeah.
Thank you. Well, that reflects the point I'm putting to you. You're saying it's temporary, which the Inspector Wyborn acknowledged, but still the Inspector acknowledged that paragraph 81 of the framework requires that significant weight is still applied to that.
True, and then finishes that by saying this is tempered by the temporary nature of the build period. So it's a sort of a flash in the pan, as it were, in that is that, yes, there is significant weight, but over the lifetime of the development, that's not a lot. Really.
Right, so you afford it limited weight. Can I take it actually that the Inspector can correct your evidence and actually we can read across what's said in paragraph 59 as being applicable to this development proposal?
That would be a point for the Inspector, yeah.
Well, I'm asking you, do you agree that?
Yeah.
Yeah, thank you. Okay, biodiversity net gain, just as a matter of principle, that was sent to the local planning authority on the 6th of May prior to the production of the proofs of evidence, wasn't it?
Within the statement of case, do you mean?
No, the calculation that's relied upon before the inquiry was sent to the local planning authority before the proofs of evidence on the 6th of May.
I can't confirm yes or no on that.
Okay, very well. As I understand it, you don't attach weight or you temper the weight to that because it's an outline proposal.
Correct, yeah.
What weight do you attach to the 44.13, albeit you don't confirm one way or another?
Well, in terms of the figure, none, because we don't know that. In terms of the principle of can biodiversity net gain be achieved, some, because it's not been quantified as of yet. So it's an outline scheme. Those details would be known with a full application or reserve matters. So acknowledge that there'll be some benefit, or some weight, sorry, to be given to that, but it would be remiss to say that we could say with certainty it's a much higher level than that, because we just don't know.
And just on this point, Mr. Farmer has given evidence that it's at the 44.13. As I understand your position on this, you don't dispute that, but equally you haven't independently validated it.
It's not been confirmed, so it's unknown whether that is actually achieved or not, because it's an outline scheme.
Right.
So it's unknown.
If you just pause there, I just wanted to turn my back, but I think we might be done.
Thank you. So, thank you, Mr. Stevenson. I've not got any further questions. Mr. Leader, have you got much?
Not long, sir. I would have thought 10 minutes at the outside.
Are you okay,
That's
Mr.
fine, yeah.
Stevenson, to
Let's
carry
carry
on?
on.
Prefer to carry on?
Thank you. Right, Mr. Stevens, would you like to pull up the statement of common ground, please? Go to page 13.
Page 13, you say?
Yeah.
Yep.
Now, you were asked lots of questions about the green belt in the emergent local plan. Do you recall those?
Yep.
Now, I'll talk to Mr. Wakefield in due course about what he wrote in his proof, but leaving that to one side, do you see the second bullet point under the heading Merging Local Plan?
Yeah, consultation on pre-submission plan November.
No, I'm looking at page 13 under
Yeah.
the heading Emergent
Oh,
Local
sorry,
Plan.
as a result, yeah.
Second bullet point.
Yeah.
Yeah. Reading what that says, how much weight do you say the inspector should attach to the points that you made in respect of the emergent local plan during cross-examination?
As is agreed there, at most very limited, so low.
Good. Next. You were asked some questions about whether or not, in preparing the proof evidence, you had taken account of the absence of the 5-year supply, which is conceded at this inquiry.
Yes.
Could I ask you to take up your proof, please? And I'm going to refer you to some parts of it, and I'm going to ask you a question about what they mean. So if we could begin on page 15, please, paragraph 47. Now, you say at 47, if the most important policies for determining the application are deemed to be out of date, the development plan policies can still be accorded great weight. Yeah?
Yeah.
And right, just note that. That's the first point. Next point, page 25, please, paragraph 86. I acknowledge that in principle, paragraph 11D is engaged if the basket's most important policy for determining is out of date, or if the council cannot demonstrate a 5-year supply of land. However, on the facts of this case, I have concluded that paragraph 11D does not apply by reason of subparagraph 1 for the reasons set out above. Yeah?
Yes.
Sorry, which paragraph was that?
Subparagraph 1, it says, that is of paragraph 11D of the NPPF, and then the final reference, and we'll get to the punchline. Page 32, please. Paragraphs 115 and 116. Just read them to yourself, would you? I don't want to read them out. And tell me when you've read them.
Yes, I've read those.
Good. Now pull out the framework, please, at paragraph 11D. Just remind yourself what little paragraph I says, would you?
Paragraph I under D.
Yes.
I have that, yes.
Just out of interest, why would you bother referring to little paragraph I of subparagraph D? In what circumstances would that be relevant?
Where there are policies that protect assets of particular importance, so
In
heritage.
what circumstances, Mr. Stevenson, is it relevant to go there, you're applying 11D?
I don't mind deleting this because we agreed all this.
We did, didn't we? So, well, then I'll lead. Mr. Stevenson, when you wrote the paragraphs I've referred to, did you do so on the basis of the 5-year supply?
Yes.
Yes. Now, on that basis, did you take account of the absence of a 5-year supply when you wrote your evidence and attributed weight to various matters?
Yes.
That's sorry, that's I'm not contending because the witness expressed.
Well, that's why I didn't lead. I just said, did you?
The point about the application of paragraph 11, the witness expressed the acknowledged at the time of proof evidence the council contended there was a bias one, and that's why he didn't acknowledge it. He even described it as an oversight.
He did say that, but for the reasons I've taken Mr. Stevenson to, we can make submissions on whether that answer was a fair one in the circumstances, because I make submissions on the basis that it plainly wasn't a fair set of questions and a fair answer. The questions were unfair because when one reads the evidence, it's blindingly obvious he did know it wasn't a 5-year supply and acknowledged it.
Yeah, carry on, but
Thank you.
put the questions to Mr.
I will do so.
Stevenson.
Right. The next question arises from the suggestion, as it was put to you, that any conflict with CS5, and there were certain other policies mentioned, I won't refer to all of them, would be, to quote, academic. Do you recall that?
I do, yes.
Well, can you just help me with this? If the appellant concedes conflict with some policies, but not others, and it is found during the course of an inquiry that policies that the appellant said were not offended turn out to be offended, is that a matter of academic interest, or is it something to which one would attach more than academic interest?
Absolutely.
Well, absolutely what?
It's not a matter of academic interest, it's material.
And is the conflict with CS5 that you find academic?
No, it's material.
What about policy DM10?
The same, DM10 sort of amplifies on CS5, so the same answer there.
Now, I'm not going to ask you any more about DM11 than this. Could you turn up the statement of common ground, please? Do you have to hand, or rather, could you please turn up page 9, first of all?
Yep.
Under the paragraph 4.3, it says the following policies were considered as part of the application. Do you see that?
Mm-hmm.
Turn over the page to paragraph 10. Did you consider policy DM11, Mendip Hills area of outstanding natural beauty?
Yes.
And then there was a discussion about the importance you attach to that policy. Well, that is something that I shall take up with Mr. Wakefield in due course. And that completes my re-examination. Thank you very much. Oh, I'm so sorry. There's one last point I want to take the witness to. I do beg your pardon, sir.
Yep.
You were asked about the application of the tilted balance.
Yes.
My learned friend has asserted, in putting questions to you, that you accept the most important policies for determining the application are out of date.
Mm-hmm.
And he put paragraph 11 to you in a certain way. Could you turn up paragraph 11 again, please, at the framework, that is? Now, what my learned friend put to you, and he didn't brook any argument on this point, was he made you read paragraph D, conclude that the policies were out of date, and then asked you to apply paragraph I.
Yeah.
And footnote 7. That was his approach to you, and you answered the questions on that basis. How did you approach this matter when you wrote your evidence, please?
If you like, the other way round. Looked at paragraph I, thought, are there policies that protect, etc., and concluded that yes, there were. And so therefore, tilted balance was disapplied.
And how does the tilted balance come to apply? You're having disapplied it in the way that you did. If it were to apply, how could it be applied?
In the first instance would be from an absence of a 5-year land supply.
Right, well, let's take it in stages. You said you applied subparagraph I. Why did you apply subparagraph I? What was the basis on which you sought to apply it?
In that there are policies that protect, in this case, heritage assets.
Yes, and in what circumstances is it relevant to consider those policies which protect heritage assets?
In what circumstances? Sorry, whether the...
Oh, it doesn't. Do you know what, Mr. Stevenson? Don't worry. I'll take the matter up with Mr. Wakefield. Thank you very much, sir. That is my re-examination now concluded.
Thank you. Thank you, Mr. Stevenson. Okay. So that concludes the council's planning evidence. Thank you. We're on track for an early lunch, but was there something you wanted to draw to my attention before I just want to go to the gentleman at the back? Would you want?
I was going to suggest an early lunch as well, so
Yep.
that's okay.
Yep. Okay. Sorry, sir, at the back. I would have come to you sooner, but we were sort of midway through the council's evidence, and it wasn't an appropriate point. You've come in on I think we're on day 5, so I presume you may well have been following it. But did you want to speak to the inquiry?
Thank you, sir. My name is Winstone, John Winstone. I had intended coming on the first day, but I was unable to.
Yep.
And the pins in clerk to the inquiry suggested that I brought in a statement
Yep. So okay.
this morning, which I have here. What I would like to do is give you a copy of that and the 2 sides of the inquiry, further copies. And if you have any questions you wish to put to me, I'm unable to stay for the rest of your session today.
What I can do, if you're willing, I'm happy to. There's a good time now, so if you wanted to speak to the inquiry, we could hear you now. Is that okay?
Well,
I'm not going to sort of accept a statement at this stage because we've covered a lot of ground already. But if you do wish to read it out, or
well, it's 15 pages.
Right.
It does bear on what you've been talking about this morning, but from a rather different point of view. I'm loath to attempt to read out 15 pages. I can try and summarize it for you, if that would be helpful, in 2 or 3 minutes.
So what issues have you written in already?
I sent it out last night to all parties, but I think my email to you didn't get through.
Yeah, but have you already written in on the in response to the consultations on the appeal and the planning application?
I wrote in initially a month and a half ago saying that I would put in a statement.
Right.
Which I now have for your assistance.
Right. So so you haven't put that information in before now, or mentioned?
Well, only in summary terms.
Right.
I sent that to Pins. I don't know whether you've seen it, sir. But I'm very happy to try and summarise as briefly as I can what is in the written statement.
So are you a local resident?
I was a local resident. I've now moved. We used to live in Front Street in the early 90s.
Yeah.
Opposite the appeal site.
Okay.
And I'm a retired architect.
Okay. So you're commenting in opposition to the scheme?
Yes, I'm supporting the council, but I'm speaking on my own behalf.
Yeah. Okay. I have read your comments on the. I can't recall whether it was on the appeal or the original planning application. I propose to hear from the gentleman now, if that's okay. with you, if you want to come down to the bottom, if you do give evidence, be prepared that the parties may have questions of you. I suggest you do read out as much as you want, because I think we've already heard the evidence on heritage and ecology already, as you know, as we've gone through. So I can't accept sort of additional sort of written evidence at this stage, but I'm happy to hear what you say. But if you would come down and sit at the,
Thank you very
the
much,
table, I'd greatly like to hear from you. Are you okay? Would you like some water? Are you
No, I think I'm okay. Thank you.
okay? So, are there any qualifications that you'd like me to be aware of, or the inquiry to be aware of?
Well, I was an architect working on my own account since 1977. I was a chartered architect specializing in conservation. Worked from Ilex House, which is at the end of Front Street. I was an English Heritage commissioned architect during the 90s, the duration of that scheme, and I retired in 2014.
Okay, thank you. And you can you give me your full name again, just? So.
John Winstone. John Winstone with an E.
Could you get Mr. Winston some water, just so he's comfortable?
Thank you.
Okay.
So
whenever you're ready.
Thank
please.
you. Well, I wanted to speak on 3 items: the conservation area, the effects of development on various heritage assets, both designated and non-designated, and thirdly, on a criteria for housing sites coming forward in the local plan, which is not, is not contained in North Somerset DC's selection of such sites. So taking the first point on the conservation area, I first came across this in 1989 when the 2 counties, that's Avon County and Somerset County, were preparing the AONB. And of course at that time they provided a settlement area, a setting area for the AONB, which includes Churchill. That, in fact, was contained in a plan and referred to in the written statement. And at that time, too, the settlement area for Churchill was first designated. Settlement area has remained unchanged since 1989, as you know. The importance of the setting area remains today, but in fact the map was dropped at the next iteration of the AONB, but it remained in the written statement as for Churchill, the Vale of Churchill to be part of the setting area of the AONB. The next aspect of the conservation area is the question of views and the critical views which were contained or are contained in the conservation area statement. The conservation area was designated much later on, of course, and is a matter of concern to me because of its boundaries. It is unusual, I think it's fair to say, that the conservation area includes new land outside the settlement boundary to the west, namely much of the appeal site, but in doing so it also excludes the manorial group around the church. So it includes an area of open fields, which is part of the appeal site, and in doing this, it is actually emphasizing the non-conformity part of the development of Churchill and excluding the medieval part. I see no logic in this, and in fact I have asked for an early review of the conservation area to include the church and the manorial group. That was suggested at the first iteration of the, sorry, not the first iteration, the first consultation on the proposed conservation area, but it was then dropped as an issue. The council were happy, apparently, with these boundaries. So the question of the manorial group has not been taken forward. The other aspect of the conservation area document, the written statement, is that I think it doesn't adequately discuss views. It does describe them, but the description is fairly brief. The second part, as I wanted to mention this morning, was the effect on the various heritage assets. The conservation area statement describes the locally listed items, and I think there are 4: Old Farm, Bell House, Ford Cottage and Church Farm. But other than Church Farm, which is opposite the appeal site on the corner of Hilliers Lane, none of these have any significance. Church Farm would, of course, if it was a working farm, but it's long since to be a working farm. The next section of designated assets are those on the Somerset Her, HER. I asked the council for a list of hers within a 1,000-metre radius of the parish church, and the total is 74. The appellant's archaeological desktop study tallies 48. Whichever figure you go for, the implication is that this is not only an existing landscape of quality, it's an important historic landscape. And there are several aspects of the HERS, the present HERS list, which are a bit of a worry to me. I had an email from DM Archaeology to the effect that in the whole of North Somerset, the HER is pending 1,200 items which are not yet on the list. I don't know how many of those are in Churchill, but I can tell you that there is one significant one, and that is the one I want to mention on Windmill Hill, which was published in 2018 in the Somerset and Natural History Proceedings. This is a large area of geophysics to the north of the appeal site on the escarpment of Windmill Hill. I have attached this as an appendix sheet. In brief, it describes the findings of the geophysics as an Iron Age settlement. It clearly is important. It's not scheduled, of course, because it hasn't been picked up even by the HER yet, although they have promised to do so. So it's not scheduled, but it clearly has an important relationship with Dolbury Hill Fort. So here we have an historic landscape which passes via its footpaths between Dolbury and Windmill Hill. There is no account of this in the appellant's archaeological study. And indeed, the problem with that study is that when they carried out, at the council's request, various trenching, which largely proved negative, but not actually entirely, they had no hypothesis on which to judge the findings of the trenching. So the watching brief missed an important aspect which does actually show up on their geophysics. And very briefly, so if I can tell you what that is, what I believe it is a trackway or a boundary consisting of two possibly diverging lines crossing both parts of the appeal site. And I've marked this on a plan with a red dotted line. This is a very faint trail, but it does relate to the emparkment of Churchill on Windmill Hill, which is medieval or later. And it aligns, it's clearly not an architectural feature, but it aligns with or runs into the farm in Front Street. And my analysis of the HERS items is that Churchill was not emparked for deer, but it was emparked for the farming of geese. And this evidence for this is quite clear, not only in Duck Street, which is a hollow way to the north of the church, but on the other side of Windmill Hill there are two farms which have goose in their names. The farming of geese is familiar, certainly to me. I now live near Wells. There is such a farm in Westbury sub Mendip, and there was one at Limpsham. And these were medieval farming practices involving the driving of fowl to market, and on the record these droves included up to 2,000 living ducks, geese, what have you. And that appears to be the farming explanation for the emparking of Churchill. And finally, section 3 is, I can be quite brief, and I think so you may have noticed this in my initial comments, and that is the question of pollution in topsoils in Churchill and indeed in other settlements nearby, caused by the glaciation of the Mendip Hills, and that was a considerable process. Mendip Hills were approximately, if you read the geographic information online, were nearly twice as high as they are now. And what was spread by the glacier was levels of cadmium which were found to be present at Churchill Court in a report which I don't unfortunately have, which prevents or reduces the production of vegetables. Now you may say it's a rather curious thing. I'm no chemist, let alone grow a lot of vegetables. But clearly it was a problem to Churchill Court. It was found in Sandford, and this cadmium is spread in isolated pockets throughout North Somerset. It seems to me that this is a criteria for the selection of housing sites, which has not hitherto been taken note of. I raised it with North Somerset at the first local plan inquiry. Council did nothing about it as far as I know. And I simply point out to the developer that should he succeed in any respect with houses on the site, that those houses, unless a lot of topsoil is brought in, will disadvantage the owners of those houses. I think that probably is quite enough. Sir, if any of these diagrams are of use to you or of interest to the other parties, I'm very pleased to let you have a copy.
Okay. Thank you for that. Have you said everything that you wanted to say?
I have, thank you very much.
Thank you. Just stay there at the moment. Have you got any questions?
No, so I will have to take instructions on a few points of it if you've got other questions.
All right. Okay. Would it help you to have a copy of the document? Or are you happy to rely on what you've just heard?
If we go,
So I'm not, as I said to you before, we've already heard the heritage and evidence, so I'm not formally accepting that document, although I have heard what you've said. But if you could give a copy to the appellants team for them to cover it, and the council as well, please.
Thank you, sir.
Okay. If they do decide to admit it to the inquiry, it will appear on the list of documents at the end of the decision. As you've spoken, I should have said before, your name will also appear in my decision. You're happy with that?
I am. Thank you very much for
Okay.
for hearing me this morning.
Thank you very much for coming along. So do you have 2 copies there? Fantastic. If you just give them to one of the parties, though. Okay, is there anything else anybody wish to draw to my attention? No? No? Okay. In which case I propose to adjourn for lunch. We'll stick to the timetable and we'll come back at 1. If that's okay with everybody. I think we've all probably got things that we could be doing with that time, so that's
is it 1 to 45 minutes? So we have to be out.
Sorry, it's 2. It's 2, of course. It's 2. I sort of, I said we'd stick to the timetable, and then I altered the timetable, so I do apologise for that. So we'll have an extended lunch, and we'll adjourn till 2. Okay.